Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. After what seems like many weeks of non-citizen losses, we've got a bit of a gluttony of wins this week, including from none other than the highest court in the land. I've got to start with them. But before I do, NBA fans, let's go Heat. Can you feel the heat down in your soul? It's Miami Heat. We can't be beat. It's Miami Heat. Looking forward to eating those words in a few weeks. Now, some cases. First is Santos-Zacaria v. Garland, published by the U.S. Supreme Court on May 11th, 2023. Supreme Court season is upon us again. It begins. With the court using the word non-citizen throughout, intentionally, by the way. And hey, the Supreme Court season had to begin at some point, so if it was going to begin, it might as well be this way. A unanimous decision overturning the Fifth Circuit's fairly untenable exhaustion requirement authored by Justice Jackson, her first immigration decision since being elevated to the High Court. Rejoice, Circuit Warriors! We need not file endless cycles of motions to reconsider with the BIA when the BIA makes a mistake to challenge the BIA's mistake. This case is about those pesky jurisdiction stripping provisions at INA Section 242. Specifically, INA Section 242 D1. Because immigration courts are technically administrative agencies, as with all agencies, to challenge agency action in federal court, quote, a non-citizen who seeks to challenge an order of removal in court must first exhaust certain administrative remedies, end quote. Historically, that's been simple enough. A non-citizen must appeal the immigration judge's decision to the BIA, and then lose. Regarding this case, we discussed the facts on episode 90. Because it's not relevant to the holding, suffice it to say that Miss Santos-Zacaria goes by the name Estrella and is a transgender woman who is attracted to men, and she is an asylum seeker from Guatemala. She was removed once before, and when she returned without authorization, was placed in withholding-only proceedings. Both the IJ and the BIA denied her claim. On petition for review to the Fifth Circuit, Ms. Santos-Zacaria, quote, contended, among other things, that when the BIA concluded that the presumption of future persecution was rebutted, it had impermissibly engaged in fact-finding that only the immigration judge could perform, end quote. I guess Ms. Santos-Zacaria established past persecution. I hadn't recalled that. Anyway, Ms. Santos-Zacaria alleged that the BIA had messed up in its own right, separate and apart from the IJ's mistakes. The BIA had engaged in improper fact-finding. But the Fifth Circuit held that it lacked jurisdiction to review that argument, because Ms. Santos-Zacaria had not filed a motion to reconsider with the BIA, alerting the BIA of its alleged mistake and giving the BIA an opportunity to correct its mistake. The Fifth Circuit had developed this kind of unique jurisdictional requirement over the last few years, and not all judges on the Fifth Circuit were happy about it, including the dissenting judge in Santos-Zacaria itself. And indeed, oil hadn't even raised the issue before the Fifth Circuit. The Supreme Court took up the issue because the circuits are in a bit of disagreement, and to help Ms. Santos-Zacaria, of course. And as I mentioned, the Supreme Court overturned the Fifth Circuit. And ho boy, nerds, as it turns out, the Supreme Court first held that INA Section 242D1, quote, is not jurisdictional, end quote. I can barely stand still at my microphone. See, if a rule is jurisdictional, a court can't touch the case if the rule isn't complied with. But if a rule is non-jurisdictional, like a claims processing rule, a court can. Quote, non-jurisdictional rules govern how courts and litigants operate within those bounds, end quote. Even if not complied with, a non-jurisdictional rule won't tank a case under certain circumstances. To the court, INA Section 242D1 is clearly an exhaustion requirement, which in actuality, quote, is a quintessential claims processing rule, end quote. Remember that in your district court complaints and motion to dismiss defense briefs, everybody. Explaining its rule in a sentence that aptly describes the Fifth Circuit's now vacated requirements, quote, if exhaustion is jurisdictional, litigants must slog through preliminary non-judicial proceedings even when, for example, no party demands it or a court finds it would be pointless, wasteful, or too slow, end quote. Doesn't make sense to the court. Plus, the statutory language at Section 242D1 appears to indicate that unlike other neighboring provisions, this statute isn't jurisdictional. Okay, but need non-citizens nevertheless exhaust their remedies by filing a motion to reconsider with the BIA, jurisdictional or not? Thankfully, no. Section 242D1, quote, does not require that Ms. Santos-Zacaria seek reconsideration from the BIA as the Court of Appeals believed, end quote. Whether exhaustion is required turns on whether the administrative remedy is available as of right. But as indeed the Fifth Circuit has itself held post-Patel, a motion to reconsider is discretionary for the BIA. And, quote, it is well established that a remedy is not available as of right if it is discretionary, end quote. The BIA has discretion to deny a motion to reconsider. It must follow the law in exercising its discretion, but the adjudication is discretionary. So a motion to reconsider is not a remedy of right. And that means it's not required to exhaust administrative remedies before a litigant files a petition for review in circuit court. Restated, non-citizens wishing to bring their claims on petition for review can save thousands of dollars in wasted motions to reconsider, and the BIA has avoided an increase in its motion workload of probably tens of thousands a year. Rejoice one and all. Plus, recognized Justice Jackson, if motions to reconsider were required, non-citizens would in effect need to give up their direct petition for review and wait until their motion to reconsider was denied to petition for review, which might in turn mean that they abandoned certain arguments. Or maybe file two different petitions for review for the same case but on different issues? It's a bit insane. Or as the court put it in Supreme Court language, quote, we decline to interpret the statute to be so at war with itself, end quote. To put a pin in it, the position of the Fifth Circuit and the Solicitor General, albeit kind of forced upon the SG, quote, presents a world of administrability headaches for courts, traps for unwary non-citizens, and mountains of reconsideration requests for the BIA, filed out of an abundance of caution by non-citizens unsure of the need to seek reconsideration. For the reasons discussed, we are confident that Congress did not adopt such a scheme, end quote. Justices Alito and Thomas wrote a 3-sentence concurrence and wouldn't reach the first jurisdictional issue. Still makes it unanimous, though. Congratulations to all counsels involved. I know that there were many. And best of luck before the Fifth Circuit, Ms. Santos-Zacaria. And that is Santos-Zacaria v. Garland. Next up, Banuelos-Jimenez v. Garland, published by the Sixth Circuit on May 10th, 2023. This is a split decision about crimes of violence. Heck, when was the last time we actually had one of these in the immigration rather than sentence enhancement context? Well, here we are. Mr. Banuelos-Jimenez is from Mexico and entered the United States without authorization in 1999. Removal proceedings commenced over 10 years later, meaning that if Mr. Banuelos-Jimenez has a qualifying U.S. citizen or LPR relative, he's potentially eligible for non-LPR cancellation of removal. Unless, of course, he's been convicted of a disqualifying crime. Mr. Banuelos-Jimenez pled guilty in 2017 to third-degree assault on a family or household member under Arkansas Code annotated Section 5-26-309. If it's an aggravated felony crime of violence, it disqualifies Mr. Banuelos-Jimenez from non-LPR cancellation. Nor would it be a great look for discretion to have a conviction for assaulting one's wife, but worse convictions have been overcome on the podcast. Discretion's not at issue here. The IJ held that the conviction was a crime of violence, notwithstanding the fact that the conviction might occur with a mental state of recklessness, and Mr. Banuelos-Jimenez may have committed the offense recklessly. Did somebody say Borden? Yes, they did. Me. The BIA, too, which affirmed notwithstanding Borden's publication by the Supreme Court during this appeal. Naturally, Mr. Banuelos-Jimenez petitioned for review because Borden clearly said that crimes with mental states of mere recklessness can't be crimes of violence. Seems like an easy win. It was not. And before we get to it, it appears that actually Mr. Banuelos-Jimenez was deemed ineligible for non-cancellation of removal because his conviction matched the definition of a crime of domestic violence, a different removability provision that doesn't require the 1-year imprisonment term, but does require that the act be committed against a domestic class of person, and wives qualify. The analysis is the same here, though, because to be a crime of violence, the elements of the offense must satisfy the crime of violence definition used at the aggravated felony statute, as defined by 18 U.S.C. Section 16A. Now, under the Arkansas statute, quote, a person commits third-degree assault on a family or household member if the person purposefully creates apprehension of imminent physical injury to a family or household member, end quote. And before getting to the mens rea, the Sixth Circuit explained that a fear of physical injury necessarily is the result of the, quote, use or threatened use of physical force, end quote, as the immigration crime of violence definition requires. To the court, quote, the underlying act causing the fear necessarily includes at least a threat of force. Putting in fear of physical injury involves a threatened use of at least enough force to overcome a victim's resistance, end quote. That means that the Arkansas statute has, at a minimum, the threatened use of physical force required of the crime of violence definition. The Sixth Circuit held that, quote, apprehension of imminent physical injury, end quote, qualifies for crime of violence purposes. If, of course, that statute requires that the threat occur as a result of something above mere reckless conduct. That's what Borden says, right? But here it looks like the IJ might have been a bit fast and loose with the analysis. Which isn't so surprising because, after all, at the time the IJ made the ruling, Borden hadn't been issued, and recklessness didn't necessarily destroy a crime of violence finding. But now, according to the Sixth Circuit, the Arkansas statute requires that a, quote, person must intentionally or purposefully create an apprehension of physical injury, end quote. It cannot be committed recklessly. So we don't have a Borden issue. The crime is a crime of violence. Quote, while the statutes may not require the perpetrator to intend actual harm, he or she still intends to threaten harm, end quote. That cuts it, said the Sixth Circuit. Rejecting an example from the dissent, the majority opined that even shouting fire in a crowded theater involves an intentional threat of physical injury. Those in the theater would fear dying in the threatened fire. Even if the fire is not real, quoted the court, the threat to one's physical health is intentionally made. Ultimately, to the court, quote, it is impossible to conceive of a situation involving fear of imminent serious bodily injury without a threat of force, end quote. So the majority denied the petition for review and issued a holding about apprehension and crimes of violence. From the dissent. In dissent, Judge Gilman rejected just about all the logic employed by the majority. To Judge Gilman, the threat of injury is not the same as the threat of force, nor does apprehension necessarily result only from a threat of injury or force. Interesting arguments to make in other circuits when the issue is about a threat and creation of apprehension. Judge Gilman also notes quite the argument for other circuits, applicable in many contexts if you have the legislative history wherewithal. Quote, "The Arkansas legislature has shown itself perfectly capable of narrowing the scope of conduct encompassed by a statute when it so chooses. But the Arkansas legislature did not similarly narrow the scope of conduct prohibited by Arkansas Code, Section 5-26-309. I would honor that choice." End quote. Not going to get into all the nitty-gritty, but suffice it to say, when a state legislature changes one criminal statute but not another, take note. It might be relevant for the future. And that is Banuelos-Jimenez v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Moving on to Ishmael, the Attorney General of the U.S., published by the Third Circuit on May 11th, 2023. This case is quite the case. Strap in. And before we begin, the parties in the Third Circuit call Mr. Ishmael Mr. Kosh, so I of course will as well. Mr. Kosh is from Liberia. He is not Portuguese, but he entered the U.S. with a false Portuguese passport in 2001 through the Visa Waiver Program. Liberia is not a visa waiver country. Portugal is. If Mr. Kosh is Portuguese, he gets to come into the U.S. for 90 days without a visa. But of course, Mr. Kosh is not Portuguese. If you come through the Visa Waiver Program, you waive all rights to challenge removal if you overstay, other than through asylum. You actually have to sign a document waiving the right to removal proceedings, but you can still receive asylum-only proceedings, where of course you can only apply for asylum, withholding, and protection under the Convention Against Torture. We're not going to send people back to their country without a hearing if they fear persecution, even if they're from a visa waiver country. So the U.S. has decided. Once in the United States, Mr. Kosh fessed up and he sought asylum. Although it's a bit debated in the circuits, it's generally the law, and it is the law recently in the Third Circuit, that even if the non-citizen is not actually a citizen of a visa waiver program country, the non-citizen is still limited to asylum-only proceedings if they enter through visa waiver. They can't have their cake and eat it too. You can't enter visa waiver fraudulently and then get full-fledged removal proceedings. Asylum only for Mr. Kosh. But that's what he wanted anyway in 2001. Because after all, as he testified, in Liberia, quote, his family members were involved with the United Liberation for Democracy political party, they faced significant violence and other dangers, and his father had been murdered and Mr. Kosh himself was arrested before escaping prison and fleeing, end quote. And wouldn't you know it, Mr. Kosh got asylum. He then married and he had 4 children in the United States. It appears that he did not, however, seek to adjust to lawful permanent resident status under the Special Adjustment Statute for Asylees and Refugees at INA Section 209. Why not is beyond me. He traveled with his asylum status too, re-entering the U.S. as an asylee in 2005. And then in 2006, he became involved in a large tax fraud scheme for which he was ultimately convicted in 2016. Over 4 years in prison and over $200,000 in restitution. During all of that, it seems, he figured he should probably apply for adjustment of status, but USCIS, expectedly, denied it because of his criminal activity. Although, for asylees, USCIS could waive the inadmissibility, quote, for humanitarian purposes, to assure family unity, or when it is otherwise in the public interest, end quote. A very favorable form of adjustment and waiver at Section 209. Denied here. But USCIS did not, it seems, place Mr. Kosh in removal proceedings after it denied. Instead, ICE moved an immigration judge to reopen those asylum-only proceedings way back from 2001, a motion that an IJ granted, and then ICE sought to terminate Mr. Kosh's asylum status from 2001. Very sneaky, ICE. That would limit the relief available to Mr. Kosh, and his conviction is likely an aggravated felony, making him no longer asylum eligible. Something that ICE certainly knew. Mr. Kosh, of course, fought back. He moved the IJ to terminate his asylum-only proceedings, arguing that ICE was being too cute by half, and that if DHS sought his removal, they needed to initiate full-fledged removal proceedings, where Mr. Kosh would have the ability to apply for adjustment of status again under INA Section 209 before an immigration judge. And of course, he'd have available that favorable waiver that I just mentioned. An IJ denied Mr. Kosh's motion and then denied asylum, withholding of removal, and cat protection in Mr. Kosh's reopened asylum-only proceedings. The IJ found that the crime barred asylum and withholding of removal as a particularly serious crime, and Mr. Kosh didn't warrant cat protection as of 2020. Appealing pro se, Mr. Kosh lost before the BIA. But Mr. Kosh had attorneys before the Third Circuit, and he won. Although the Third Circuit agreed that Mr. Kosh has been convicted of an aggravated felony that would bar him from asylum and likely withholding of removal, aggravated felonies don't bar adjustment of status unless the aggravated felony also matches an inadmissibility provision. Usually, but not always, a crime involving moral turpitude. Doesn't matter, though, if Mr. Kosh is properly in asylum-only proceedings, because then he can't apply for adjustment of status by statute. But he is not properly in asylum-only proceedings, said the Third Circuit. Even though Mr. Kosh gave up his right to removal proceedings when he entered fraudulently through the visa waiver program many years ago, quote, the visa waiver program no longer applies to an individual who leaves and re-enters the country as an asylee without signing an additional waiver of defenses to removal, end quote. The Third Circuit's rationale didn't hinge on the fact that Mr. Kosh had already been granted asylum. That question was expressly left open by the court. Rather, the reason ICE couldn't reopen his asylum-only proceedings was because he, quote, left the country and re-entered as an asylee without signing a new waiver, not as a visa waiver program entrant in 2005, end quote. How about that? I'll note that if he had just adjusted status in 2003 before the crime and before all this happened, he also would not have had these problems. But I digress. Really, in reaching this holding, the Third Circuit simply applied contract law. The agreement Mr. Kosh signed when he entered visa waiver giving up all rights except asylum-only proceedings, read in, quote, proper context, reveals that it could apply only to any action between when the non-citizen arrives under the program and when he first departs, end quote. In further support of this conclusion, DHS makes visa waiver entries sign a new form every time they enter the U.S. Quite the support for Mr. Kosh's argument, if you ask me, which nobody ever does. Any other holding to the Third Circuit would lead to absurd results. In effect, the IJ should have never reopened asylum-only proceedings in the first place. Therefore, Mr. Kosh can, quote, adjust his status if he convinces an IJ that humanitarian purposes or family unity weigh in favor of waiving his inadmissibility, end quote. I guess? Because DHS now needs to NTA him, right? Also, a few more things to sort out on remand, but it looks like Mr. Kosh will win on those limited issues. Pretty weird case. Congratulations, Benjamin J. Hooper and Jonah B. Eaton for petitioner. Judge Porter concurred and dissented and doesn't believe Mr. Kosh is due anything other than asylum-only proceedings. Judge Porter reads the Third Circuit's Schembe decision from episode 118 broader than does the majority. But Judge Porter's interpretation didn't win the day, and so I will not dive into it further. And go check out Schembe. And that is Ishmael, the Attorney General of the U.S. That leaves us with Mendez Esteban v. Garland, published by the First Circuit on May 11th, 2023. This case is about asylum. And do you think it's a win for the non-citizen? It starts off as such, quote, fleeing death threats and physical violence at the hands of a rival political party in Guatemala, Mr. Mendez came to the United States in January 2015 seeking protection, end quote. Okay. Specifically, Mr. Mendez, who is of, quote, indigenous ancestry, end quote, joined the Litter Party in 2013. Didn't we just do one of these? Yes, we did. Mr. Santos-Zacaria from 2 weeks ago feared members of the Litter Party. I'm sure it wasn't Mr. Mendez Esteban who he feared. And the Litter Party's certainly getting more love than it did on episode 157. Mr. Mendez, quote, believed Litter's community-centric agenda, which advocated for greater investment in local infrastructure and municipal services, stood in stark contrast to what he viewed as the corrupt politics of Litter's political rival, the National Unity of Hope Party, or UNE, end quote. UNE controlled the Guatemalan government at the time, and Mr. Mendez was directly involved in challenging them electorally in 2014 and 2015. That is, until the death threats began in November 2014 from UNE members. A similar thing happened a month later in a different community that Mr. Mendez and his colleagues were distributing materials in, where a UNE member also beat Mr. Mendez, requiring an overnight hospitalization. A week later, UNE members fired a gun in the air in another community that Mr. Mendez was working in, intended as a warning to Mr. Mendez and his fellow Litter members. He fled. 7 days later, Mr. Mendez's brother-in-law was found dead with a gunshot to the chest. He was also a Litter supporter. Police were called but never investigated, and Mr. Mendez believes that it was related to the brother-in-law's involvement with the Litter Party. That's when Mr. Mendez fled to the United States. Mr. Mendez testified to all of this credibly in his removal proceedings, and an immigration judge held that it all rose to the level of past persecution on account of his political opinion, which would then usually mean an asylum grant. Problem is here that the IJ also held that DHS had met its burden to show a fundamental change in country conditions in Guatemala. The IJ found that, quote, because the UNE party is no longer in power, there had been a change in circumstances, such that Mr. Mendez no longer has well-founded fear of the UNE party, end quote. So Mr. Mendez lost. The IJ rejected Mr. Mendez's alternative basis for asylum based on his membership in the particular social group of males of indigenous ancestry who were politically active in Guatemala, believing that that's not the reason that Mr. Mendez was harmed. The IJ also denied withholding and cat protection and so ordered Mr. Mendez removed. The BIA affirmed. It relied in large part on the fact that there was a peaceful transition of power when UNE lost the election in 2015, and that the Litter Party no longer actually even exists in Guatemala. But the First Circuit did not agree. Because you see, in the First Circuit at least, when there is a past persecution finding and DHS bears the burden, DHS's burden is to, quote, prove that the conditions in Guatemala had changed so dramatically as to undermine the well-foundedness of Mr. Mendez's fear, end quote. Quite the burden. DHS's reliance on a Department of State report and Mr. Mendez's testimony that simply reported that UNE was out of power didn't cut it. Take note! In fact, quote, State Department reports, even where probative of country conditions, seldom can carry DHS's burden alone, end quote. Take note! They're just generic and never tailored to a specific case, like Mr. Mendez's particularized fears. To the First Circuit, then, quote, the critical question is whether the 2017 report demonstrates that conditions in Guatemala have changed such that expressing one's opposition to UNE is no longer an objective reason to fear persecution, end quote. Not necessarily about political affiliations. And so stated, there has not been a fundamental change. And remember, DHS has the burden. First, contrary to what the IJ apparently held, it doesn't look like Mr. Mendez ever testified that UNE isn't actually still in power. But more to the point, the First Circuit doesn't read the record as showing a peaceful transfer of power in 2014, and the complete ouster of UNE. Quote, the 2017 report contains no information about the political composition of the Guatemalan legislature, or UNE's representation in regional and local governments, end quote. Maybe UNE is out of the presidency, but that doesn't necessarily show what's happening on the ground, particularly where LITER itself was dissolved. To the contrary to the First Circuit, the record shows that UNE is active, and there is nothing indicating that UNE has stopped persecuting its political opponents. Even the IJ appears to have recognized this a bit. And quote, even if UNE had become powerless on the national level, DHS still cannot satisfy its burden with the general statements about national politics untethered to Mr. Mendez's particular, substantiated fear, end quote. Mr. Mendez's claim turns on UNE's, quote, power and influence at the local and regional levels, end quote, and DHS didn't make any showing on that. So this is a great decision to rely upon in cases where the political party feared might technically be out of power or out of the presidency at the time that the asylum claim is actually decided. I'm going a bit on and on here, but they really are great quotes on a rarely discussed issue that's often present. Quote, such attempts at improperly equating a party's diminished posture on the national level to its influence on local politics is precisely what the particularized evidence requirement was intended to prevent, end quote. And right, the Republican Party is still pretty powerful in Alabama. Similar thing. Get this too. The Department of State report states that it was believed that the 2015 elections and the transfer of power were, quote, generally free and fair, end quote. The Department of State says that all the time with so many countries. But that language, which again is always used, quote, does not rule out occurrences of political violence or particularized persecution during the 2015 election, end quote. Right? The Department of State used the word generally. My oh my. The First Circuit also didn't think it mattered that the LITER party is no more. Mr. Mendez, quote, presented the persecution he suffered in terms of his opposition to UNE, not his membership in LITER, end quote. Plus, and this is just me, doesn't dissolving the political party kind of show that the Guatemalan government isn't thrilled with LITER party members? Nor does it matter that Mr. Mendez's family remains in Guatemala unharmed. They are not like Mr. Mendez, so they don't matter. This isn't, after all, a family-based claim. And in any event where DHS has the burden, quote, assertions about remaining family members are rarely probative as rebuttal evidence, end quote. Take note. In fact, reasoned the First Circuit, the only similarly situated family member, the brother-in-law, was killed. Nor did the First Circuit care that Mr. Mendez had not been threatened since coming to the U.S. and not participating in Guatemala's political system. If you're not picking it up yet, and even though it's in the context of DHS having the burden to rebut, this decision is a must-read. I've already put it into one of my briefs. I'll leave it to my DHS adversary to discover where. The First Circuit affirmed the denial of cat protection, though. The rest is going back to the BIA and presumably the immigration judge. And so, Congratulations Patrick T. Roth from Ropes and Gray, along with Samuel L. Brenner, Emma Corino, and Rachel Scholes-Bright, who I'm sure took the case pro bono. And that is Mendez Esteban v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.